This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an insurer of a third-party liability policy has the right to control the defense, and if the insurer agrees to defend an insured, the insured may not expect it to pay independent counsel. This is because there is no free lunch, nor is there a free lawyer. The Insureds sued Mid-Continent Insurance Company for failing to pay their attorney's fees in defense of an underlying lawsuit where the Insureds alleged several causes of action against Mid-Continent, including breach of contract, bad faith, and several insurance code violations. Mid-Continent filed a motion for summary judgment. The trial court denied the motion for summary judgment, and Mid-Continent appealed. In Mid-Continent v. Harris County Municipal Utility District number 400, AN August 31, 2023 decision of the Court of Appeal, who was asked whether Mid-Continent Casualty Company must reimburse its insureds, Harris County Municipal Utility District number 400, or MUD 400, Anne Marie Wright and Cheryl Smith for fees and expenses incurred by attorneys chosen by the MUD 400 to defend the insureds in an election contest lawsuit. The dispute arose from an underlying lawsuit filed by Edgar Clayton in June of 2018. In the Clayton suit, Clayton challenged the result of a May 5, 2018 election of two open at-large director positions on the MUD 400 Board of Directors. He came in third, and there were only two openings. Mid-Continent's insurance policy was a directors and officers policy insuring MUD 400 and its directors. On July 24, 2018, Mid-Continent offered a defense subject to a reservation of rights. Mid-Continent notified the insureds that attorney Brett Harris had been retained by Mid-Continent to defend all insureds in the Clayton suit. The terms of the relevant insurance policy included the following language, quote, exclusions. The insurer shall not be liable to pay loss resulting from any claim based upon or attributable to any of the insureds gaining, in fact, any profit, remuneration, or advantage to which such insured was not legally entitled. It also provided that the insureds shall not accept at a personal cost, make any payment, admit any liability, settle any claims, assume any obligation, or incur any expense without the insurer's written consent. The Clayton lawsuit was taken to trial and was eventually dismissed in favor of the insureds while the trial was proceeding. On February 1, 2019, after the Clayton suit had been dismissed, the insureds wrote to Mid-Continent demanding reimbursement for attorney's fees and costs. The insured stated, quote, because of the potential conflicts with joint representation as well as the existence of actual conflicts due to your reservation of rights letter, the insureds defended the case with counsel of their choosing, close quote. On January 29, 2019, during the trial, Clayton voluntarily dismissed the suit against the insureds with prejudice. Mid-Continent denied the claims for reimbursement of the fees incurred by counsel chosen by the insureds in the defense of the Clayton lawsuit. Mid-Continent's attorney mailed a check made out to MUD 400 for $4,290. to pay the fees generated by the insured's independent lawyers firm between the time that it first provided a copy of Clayton's petition to Mid-Continent and the time that Mid-Continent offered to assume the defense of the Clayton lawsuit. Mid-Continent had certain obligations to defend the insureds. The duty to defend is distinct from and broader than the duty to indemnify. In determining a duty to defend, Texas follows the 8 corners rule, sometimes called the complaint allegation rule. The rule directs courts to determine an insurer's duty to defend its insured based on 1, the pleadings filed against the insured, and 2, the terms of the insurance policy. Under the 8 Corners rule, an insurer's duty to defend its insured from an underlying suit is determined by the pleadings and allegations in the underlying suit, considered in light of the policy provisions without regard to the truth or falsity of those allegations. Of course, if it accepts a duty to defend, the insurer has the right to control the defense because liability insurance policies typically, as did the policy in this case, confer on an insurer the right to control the defense of claims against the insured. Advantage, as used in the policy exclusion, refers to something like a monetary advantage. In the underlying suit, Clayton's petition refers to several election irregularities, but none of Clayton's allegations are monetary advantages gained by the insureds. After examining the allegations in the petition and the wording of the policy, the Court of Appeals agreed with Mid-Continent that the fact upon which coverage depends would not be adjudicated in the underlying election contest suit. Nowhere in Clayton's pleadings does Clayton allege that Wright, Smith, or Mudd 400 received a monetary advantage. Since Clayton's petition did not allege facts that would necessitate separate counsel, Clayton did not allege anything in his petition that would make the interests of Wright, Smith, or Mudd adverse to the interest of each other. For all of the foregoing reasons, the Court of Appeals concluded that Mid-Continent had no duty to reimburse its insureds for fees and expenses incurred by attorneys chosen by the insureds to defend the insureds in the Clayton suit. Mid-Continent had no duty to reimburse its insureds for the costs they incurred in hiring separate counsel to defend each insured in the Clayton lawsuit, since, of course, Mid-Continent had offered to pay for a single lawyer to defend all of them. The trial court erred, therefore, in ruling that Mid-Continent owed a duty to pay its insured for fees and expenses incurred by attorneys chosen by the insureds to defend the insureds in the Clayton lawsuit, because there's no free lunch and there's no free lawyer without a conflict. In my opinion, even with the 8 Corners rule accepting all allegations in the suit as true, there was simply no facts alleged that put coverage at issue. Although if there is coverage and a conflict of interest exists, independent counsel can be available at the expense of the insurer, but when, as in this case, there was no conflict, the insureds were not entitled to compel their insurer to pay for the charges of independent counsel. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. Please tell your friends and colleagues about the blog and the videos and let them subscribe as well. And you can also, if you wish further detail about insurance, insurance law, insurance coverage, and insurance claims, for a very small fee, you can subscribe to Excellence in Claims Handling at locals.com or to my Substack publications. Thank you for your attention.